7 more days. 7 more days have passed since you perpetrated your unforgivable abuse of discretion against my children and myself after I had foolishly sought sanctuary in your courtroom. I now know that you will not protect a victim of domestic violence, but instead you will reward the domestic violence abuser. You will legitimize their abuse, join in their abuse, increase and prolong their abuse, and believe that you are entitled to do so by virtue of the office that you hold and the job that you were hired to do. I submit that, however, is not the job that you were hired to do in this courtroom when you took the position 7 years ago. I submit that you have acted outside of the scope of your office, Commissioner Shelly Seymour, Department 7, Merced County, Superior Court of California, and so are guilty of an abuse of discretion, which you arbitrarily perpetrated against me and my children, and you shall be held responsible for the grievous miscarriage of justice that you set in motion with your little wooden hammer on Friday the 13th. In case you have not yet been officially notified, I will assure you that it is coming. And I will personally notify you now that an appeal has been filed with the state appellate court to reverse the harm that you have caused to my family. It is just a matter of time, and that's what fuels the burning lake of holy condemnation inside me for the wicked evil that you have caused. Time. 7 more days have passed, Commissioner. 10 out of 14 days that the lives of my children have been placed in unnecessary and unknown peril for the sake of satisfying your sick and secret schemes. Have you worn a mask on your face at all in the last 14 days? What? Were you wearing a mask in your courtroom on Friday the 13th when you hypocritically sentenced my children to the publicly administered institutions of traditional education because it was in their best interest? What? Have you stood 6 in front, 6 in back, and 6 on either side when you were out doing your business in public during the last 14 days? What? Death. 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 The only reason is the fear of death. Did you spend the last 5 out of 7 days at any of your beloved publicly administered institutions of traditional education in close contact with the elementary student body of that demographic, as I suggested that you do? Why not? Is it because you had more families that you wished to destroy from your place on the bench, or is it because of the fear of death? I surmise that it is both. You may do as you wish to the children of other people, but I am the solemn sworn protector of these little ones whose life you could care less for. And so it is a matter of time before their cries for justice are heard by the appellate court of the great state of California. Standard of review. As counsel for myself in this matter, it is my obligation to set forth the correct standard of review so that the appellate court may be able to determine whether or not there has been a miscarriage of justice. In the carrying out of its usual business, the court must act in accordance with the policy and purpose of the laws and statutes being applied within its discretion. But the court is limited to the legal principles governing the subject of its action, so that any arbitrary determination, capricious disposition, or whimsical thinking is considered to be outside the scope of the court's discretion. Where no reasonable basis for the action is shown, the action of the court is subject to reversal on appeal. If that action is outside the scope of discretion and transgresses the confines of the applicable principles of law, we call such action an abuse of discretion. If the court was mistaken about the scope of its discretion, the mistaken position may be reasonable, i.e., one as to which reasonable judges could differ. But if the court then acts in accord with its mistaken view, their action is nonetheless in error and it is wrong on the law. The pertinent question is whether the grounds given by the court were consistent with the substantive law and, if so, whether their application to the facts of this case was within the scope of their discretion under the particular statute. Statement of appeal. I submit that the facts of this case, the judgment for which I am seeking reversal on appeal, were suppressed and therefore not correctly applied within the scope of the court's discretion for their jurisdiction. It is my unwavering position that the decision of Commissioner Shelly Seymour, Department 7, Family Law Division, Merced County, Superior Court of California on Friday the 13th, to deny my request for added visitation, to also deny my request for further mediation, to coerce me to unenroll my children from our private home school, to put prohibitive restrictions in place on my ability to file any future RFOs so that these orders may be modified, to incredulously demand that my children be returned to the institutions of traditional education in the midst of an unprecedented global pandemic because it is in their best interest to grant the wishes of the responding party who is known to the court as the hostile and restrained party, and has a record of domestic violence as well as a history of violating and obstructing the visitation orders demanded by the court, at the hearing for which I had petitioned, is not in accordance with the purpose of the law, is not based on the facts, so as to be arbitrary, and, as such, it is outside of the scope of discretion allowed to the court by the Constitution of the State of California and therefore must be considered as an abuse of discretion. 7 more days, and it is just a matter of time, Commissioner. And the time that lies between this moment and the future moment, where the wrong that you have done shall be undone by a higher court than yours, is filled with peril and the real risk of death for my 2 little ones at your very hand, which is upon the gavel. Are you prepared to pay the price should my 2 children become infected with COVID-19 or some variant for the sake of your beloved publicly administered institutions of traditional education? Do you believe it is in your best interest for them to do so? What about their mother's abusive agenda of parental alienation, in which you are now complicit, for which you are now responsible, of which my children and I must continue to suffer until your illegitimate ruling can be reversed on appeal? Do you believe that perpetrating the emotional abuse against my children and I, of which you are now guilty by proxy, is in your best interest to do so? Is it not a grievous miscarriage of justice that you have legitimized, increased, and prolonged the abuse for which I came to you seeking sanctuary for myself and my 2 children? Is it not an unforgivable abuse of discretion for you to have placed the lives of the 2 little ones, whom came to your courtroom seeking protection, at an incalculable increased risk of death because you refused to allow them their right to have their social and educational needs met outside of your beloved publicly administered institutions of traditional education? You do not have the right to take away the rights of my children. You do not have the right to take away my rights as a father. You do not have the right to perpetrate these abuses by proxy upon me and my children. But you think you do. You think you are justified and that your side of the street is squeaky clean. But I guarantee you this day that the wretched, wicked, and evil thing that issued from your bench on Friday the 13th will be brought forward into the light for all to see. And you shall be judged by judges, who have not been hired but who have been appointed by the governor, and they shall find your jurisprudence lacking. And they shall find you guilty of an unforgivable abuse of discretion. And the unjust evil you have done shall be undone by the just application of law, above your head. And you will reap the bounty of shame and misery that belongs to you alone. Commissioner Shelly Seymour, Department 7, Family Law Division, Merced County, Superior Court of California. It is only a matter of time. 7 more days have passed, and the cost of your crimes against my children compound with the ticking of every second that their lives continue being endangered by your very hand, which is upon the gavel. For shame upon you. For shame upon your office. And for shame upon the entire Family Law Division of Merced County. You should know better. Death. 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 Seven more days.